All right, welcome back to Roadmap Riches to Wealth. I still like to call it Basement Tales, which is what it was. This is all about making money with buying and selling, usually distressed real estate. I mean, we'll sell non-distressed real estate too if it makes money, but usually it's distressed. But anyway, today I have been asked to introduce the topic because I have to deal with this topic, and it's a topic that you, as a potential real estate investor, will have to deal with or risk dealing with if you want to get involved in any sort of house flipping or especially if you're doing any kind of hard money lending. And that is what these guys have dubbed, I had never heard it this way, I use proper legal terminology, is the BK Boogie. And as a little background to start with, as you all know or probably know, there's a whole bankruptcy system in the United States. A lot of states have them, but pretty much everybody does it on the federal level. And it's designed so that people individually or with their business get in over their head with debts. They lose a job, they have medical problems, maybe they don't have enough money coming in to pay their debts. And then the debt collectors start hounding you and people are trying to foreclose on your house and your property. You don't know what to do. The system exists for you to file bankruptcy and to stop that process so that these creditors have to pause. You go into court and sort of sort out what's happening, and a lot of outcomes can happen. Maybe you do have to sell things off, or maybe you come up with a repayment plan under a personal Chapter 13 to pay off your creditors, but maybe at a reduced rate. All sorts of things can happen in bankruptcy. It's a good system for many reasons, but like any system, it can be taken advantage of. And so what we describe, or now I use the term as well, BK Boogie, is a situation where somebody is using that bankruptcy process to manipulate a financial situation. Maybe reasonably, maybe not. It depends on how you view the world in many ways. But so what happens when, let's say, Sam were to file bankruptcy?
I like
you like that one better than?
Let's start with, let's say Sam is in foreclosure.
Yes. So somebody is.
Am I incarcerated at the time?
Sure, if you'd like. Yeah. It doesn't matter really for this purpose.
You guys are so.
So Sam, despite appearances, can't pay his bills for whatever reason.
And he owns a house.
Drugs, maybe?
He owns a house.
Because I can make up any scenario I want now, as ridiculous as possible.
They'll be piecing this together into the whole case.
So Sam's your regular homeowner. He's got a house, and he's gotten himself into some trouble. And honestly, I think they say a large percentage of bankruptcies start because of medical debt. It's very common. Or
my health
losing.
Is my health failing too?
Yeah.
Okay.
Yeah. You can get multiple things. You lose your job unexpectedly.
All right.
So for whatever reason, the bank has had enough of delays and attempts to talk about modifying the debt, and they send them a foreclosure notice. And Sam, or let's call him Dam, I don't know. This whoever Sam represents, cannot come up with the money, not sure what to do. And so Sam individually can file a Chapter 13 bankruptcy.
Right before the auction.
Right before. So let's say the auction is
Chapter
tomorrow.
13?
Let's say your son got you in financial trouble. I mean, these things happen. And so the bankruptcy, the foreclosure's tomorrow, and you learn, not knowing a lot about this stuff, hey, you can file bankruptcy. And the bankruptcy puts in an automatic stay. That's the fancy legal term, which also makes sense. The stay stops everything. Your creditors can't pester you, at least legally.
And it also stops the foreclosure
and
auction.
most importantly, it stops the foreclosure auction.
They can't even call you your creditors.
Correct. Yeah. In fact, if a creditor, after a bankruptcy stay goes into effect, still sends you letters or calls, especially if they got notice of the bankruptcy, they can get in big trouble. You can actually sue them and get damages, even just assumed damages, even if you've not really been hurt by it, because it's meant to protect you emotionally, financially, everywhere else. So generally speaking, creditors are pretty good about respecting this because they will be learned to be good if they don't do it originally. So this initial process comes into effect for you guys a lot when you're dealing with pre-foreclosure situations. You find somebody who's in a financially distressed situation. They have a foreclosure coming up. Oftentimes you'll tell them, look, one option for you, and there are consequences of doing it we can talk about, but you could file a bankruptcy and stop the auction from going forward. If you'd like, we can buy your house for cash in a certain period of time, pays off that loan, and the whole foreclosure goes away, and it's better on your credit report, etc. But a lot of times people need more time, and so they'll file that bankruptcy, and the whole thing follows. So, but what happens with this manipulating thing is, okay, Sam or whoever it is files that first bankruptcy, and then there's a whole process that goes into effect. It's very easy. It's a small fee and a single piece of paper, and your bankruptcy starts, but it triggers a whole process. You then have to put together a lot of paperwork about your assets, your liabilities. You can do it as an individual. You can do it yourself and probably mess it up. Or you can get a lawyer, usually relatively reasonably priced, who's paid through the bankruptcy process out of your money, and can help you do that stuff. And that's the normal process. But what if I say, I don't think this bankruptcy is going to end well for me. I don't think this bad circumstance is going to get better. I don't really have a way ultimately to save this property. So some people will sort of make the moves a little bit and then stop participating in the bankruptcy. And at a certain point, whether early or late, if you as the person who filed for bankruptcy don't do the steps you're supposed to do, the bankruptcy court will just kick you out and say case is closed.
It'll get dismissed.
Dismissed, right? Exactly. The case will get dismissed. Well, once the case is dismissed, that lovely automatic stay goes away. And so typically in this kind of scenario, the lender will have gotten notice of the bankruptcy case, notice of the dismissal. Eventually, it'll work through their mortgage collections department, and they'll file foreclosure again. You figure, that's it? Well, no, you can actually file bankruptcy a second time. So, as the second foreclosure comes up, Sam says, that worked pretty good last time. It bought me several months by all of this stuff, depending on the jurisdiction you're in. It can take a long time to notice a foreclosure and get through that process. So Sam goes, I know what I'm going to do. I'm going to wait until the day before that
or the morning of. Even with the auction's going to happen at 11, I'm going to file at 9.
Which is risky, but if you have like a date stamped and time stamped thing, typically the bank that was foreclosing will even cancel a completed sale. That happened to me, actually.
Yeah, sure.
I purchased
and
a
that's
property.
What's relevant about bringing it up. You might buy a property at auction, and then they call you an hour later, and they're like, yeah, sorry.
That's happened before.
Yeah. That happened to me.
That's happened to us.
A day or 2
you
days
give them the
later.
check. You're like, can I have my check back? You're like, it's going to take a minute.
Yeah.
It's going to take a minute? The bankruptcy just got canceled
But then,
like a minute ago.
But then how many times can Sam file bankruptcy and get away with this?
Right. I don't know why it has to be Sam.
Yeah, well, it seems like the most logical explanation.
Well, we haven't even talked about the other name that's on the deed as well.
Yeah, well, and so that's
Sam owns this house with somebody else.
Well, let's keep it simple, and then we'll get to the complicated.
I know with Charlie.
Because this is kind of, I guess, the BK two-step, maybe.
Right.
I don't know, not quite the Boogie yet. So Sam likes this idea very much. Well, normally Sam's going to really have to go further through the process. And the stay will tend to end automatically because the thinking is if this happens within a year. Now, if Sam files, and let me just be clear, this gets very arcane. I'm talking about general stuff. This is in 11 United States Code 362A, deals with the stay and when it applies and when it doesn't apply. So let's say Sam files his second bankruptcy a year and a half later. Maybe he worked something out with his creditors.
Oh, a year and a half. Wow.
That counts as his first bankruptcy.
So Sam's actually making some payments.
Right.
Now, what? Maybe I made a payment after, I hadn't made payments for 6 months. I went on a forbearance thing for a while. And then we got really close to the auction. I did a bankruptcy.
Right.
And then I was like, hey, it's going to be all right. I'm going to just make a payment.
Right.
And they accepted a payment.
Right.
Now they've accepted a payment. You're like, they got to restart the foreclosure. Then they rehire someone to restart the foreclosure.
Takes a long time.
And every time that you take a big organization and try to move them through these processes, it takes them a long time.
Takes time.
And
Sometimes
a lot of times they'll sell the servicing.
Right.
So in the meantime, the servicers chase, and then suddenly it becomes New Res or some other known servicer, and that servicer has to go hire the same attorney, and that all gets dropped. And so this can string and string and string, but we get to a year and a half later to my next BK, and I'm back to BK1.
BK1.
Because I'm allowed 3.
Sort of.
Three in 1 year or 3 in?
Well, so normally if you file the second one within 1 year, typically there is an automatic stay, so you can stop the foreclosure, which is huge, as we just said. Now, technically, that stay will end after about 30 days, so it doesn't buy you as much time unless you go in and really start actively working on the bankruptcy. So,
Or
and
maybe
again,
to actively work on it in a way that's not really a good performance.
right. The problem is it good
It appears
faith?
you will be working, but then you made some mistakes.
Right, and the courts, I think, in my experience, I don't have a ton with, but I have the weird situations. If you file a second BK, they're not going to be too worked up about it because people do panic. It's not that unusual. Where you really tend to see a lot happen is normally the third bankruptcy. The stay is not automatically going to go into effect. So you would then need to go to the court and say, no, really, I screwed up the first one. I started the second one and screwed up. Please put the stay in effect. Maybe you do it a couple weeks before foreclosure. Maybe the court doesn't, whatever. So what's a better thing to do? Well, as you guys know, typically on a individual residence, a husband and wife or children, multiple people can be on title as tenants in the entirety. At least in Virginia, that's the term. It can vary in different jurisdictions. But if for whatever reason Sam has filed his bankruptcy, just Sam files it. Now, if somebody's really doing a good faith, they'd probably do it with their spouse. They would probably both file bankruptcy. But if they're smart and want to do what we call the BK Boogie, Sam files bankruptcy, messes with it, it ends up going away. Then his wife files bankruptcy. And that
stretches my timeline for my 3 filings in a year out. And so I can push it past a year in all likelihood.
Right. So then your second filing then stops everything again. And you figure, well, that's got to be it, right? Well, no, because your spouse then has a second filing.
That's it.
And if everything can get extended, you may be able to start the whole dance over again. And
it's hard to believe, isn't it?
Yeah.
And yet, we've got guys. How many times did our friend down there?
So we have a couple.
Alexandria.
Yeah, we have a couple stories. As a matter of fact, both of those stories are in Alexandria, and so the one property address was, and I'll say the address because they've eventually sold it by now. 103 Cameron Mews, which is by the torpedo factory.
It's a great address.
Old Town Alexandria.
Beautiful brick townhouse.
And we've been up in that house a few times, and so the house was owned by 2 people.
Mm-hmm.
They collected antiques. It was very pretty.
Oh yeah, they collect. Remember that Declaration of Independence and some other things.
All kinds of stuff.
And so, but he was literally 8 blocks from the Alexandria bankruptcy court, the Eastern District,
where we have spent some time
of Virginia.
Yeah.
And so, the thing is, though, the house was worth about $1.4 million or $1.2 million. But
this is a while now.
This is a long time. But on the first trust, they only owed like $280,000. Mm-hmm. They couldn't make the payments for whatever reason. And so he wouldn't
sell it.
So he wouldn't sell it. He refused to sell it. So he would go up, house would go into foreclosure. He would get published in the newspaper. It was a Samuel White.
Charlie would email him.
Oh yeah, I would email him. And he would then
try to buy the house.
Yeah, because we're trying to buy we're trying to buy. I would either call him or email him because we were trying to buy the house it was a great pre-foreclosure lead, so we were trying to buy it.
And he's a nice guy. He's
communicative. Great guy.
Mm-hmm.
So he would then just walk his way up the street, King Street, as you know, in Washington Street, and he would go ahead and file his, at the time, Chapter 13.
Right.
And then the bankruptcy would get, the foreclosure sale would get canceled.
Right.
Okay. 2, 3, 4 months go by, nothing happens. Then all of a sudden, the substitute trustee noticed that the foreclosure ad would show back up in the newspaper. Mm-hmm. He was up for foreclosure again.
Meats on the grill.
And so we'll get into that in a second. And then what he would do is his wife would then go up, walk up those 10 blocks, go ahead and file her Chapter 13. Now, when you file a Chapter 13, so you've got 2 different kinds of personal bankruptcies. You've got Chapter 7 and you got Chapter 13. Chapter 13 is like a personal reorganization.
To fix it. Yeah.
To fix it.
You're going to try to, just so people understand. So 13 means I maybe temporarily I can't meet my bills, but I did get a new job.
And I can fix it.
I don't need to liquidate.
And I can fix it.
I don't need to sell everything.
And 7, that's the word, is liquidation. I'm just going to, I have to sell off my assets to pay people as much as I can. And you get some amount, you get to keep, you get a new start. And then all those debts, credit card, medical, all gets wiped away. probably your house has had to be sold. Sometimes it's exempt, sometimes it isn't, and you go forward. So in this case,
Right.
they're doing the 13.
So they're doing a
reorganization.
13. So part of the 13 is you file the bankruptcy, let's say call it day 0 or day 1.
Mm-hmm.
Then 30 to 45 days goes by and you have to file a reorganization plan
Right.
in Chapter 13.
Right.
So what these guys were doing is they would wait for the maximum number of days to go by. Let's say it's 45 days. They would not file the required paperwork.
Right.
So they would not file the reorganization plan. The court would eventually find out about it, maybe a
Right.
week or two later.
And it has like calendar checks and stuff. Yeah.
Realize they didn't file the paperwork. They would then dismiss the bankruptcy,
Right.
which means the stay is lifted. The law firm, Sam White, who's foreclosing, would eventually find out that the stay was lifted and that they can re-foreclose.
Right.
They would finally re-foreclose, and then the whole thing would start over again.
Right.
Okay.
And let me say, by the way, some smart people, and this shows you, by the way, we're not talking about, oh, this is people who have no money or terrible. You can have a lot of money and go into Chapter 13 legitimately. You can't pay your bills.
Right.
But some people in that scenario they'll get a notice first from the court. You haven't done your plan. And you can turn and say, oh, gee, I'm sorry. I didn't know how to do it. I'm screwed. Can I have more time? And so there's ways that you can sort of stretch this out. Now, the court might just flat out dismiss it, but people will try to drag it out who are sophisticated.
But it got very personal because each time the foreclosure ad notice would come out in the newspaper, I would either call the guy or send him an email.
Right.
And I would say, hey, look, your house is up for auction. We'd like to buy it all cash. Well, it's funny because each time that this would happen, the guy would literally write me back and say, hey, Charlie, let's meet for drinks in Old Town at such and such
Charlie
a
doesn't drink.
place.
He'd be over at a wine bar.
Drink, right?
At a wine bar.
So I met this guy a couple times at different bars to have drinks
sure,
with the guy because the guy needed a friend. He was such a nice guy.
I think I even was down there at that Union Market.
Wherever it was. I met him at a couple of different places to have drinks. And so it got to this whole escapade that eventually, so he would file the 13, the wife would file the 13. This went on and on for 7 or 8 years. And basically it got to
it's hard to imagine, isn't it?
Yeah, it's hard to imagine. And basically I told the guy, you need to write a book on this.
Well, and because
this is interesting. You should write a book on what you're doing.
Well, let me interject. You say, well, why would somebody do this? So, because it's not like the loan is not going up in interest and penalties.
He's just going to
and
consume the
attorney's
whole
fees.
house.
Right. Where the smarter thing probably in this case, in a lot of cases, is to sell the property.
Oh, for sure.
But let's say the property's is underwater or close to being underwater. This is a great way to get rent-free place to live.
That's exactly what they did.
Right.
But remember, though, what was going on in this particular 7 to 8 year period of time was that he had a low first trust amount, like $280,000. The house at one time was worth $1 million, but over a period of 7 or 8 years, it kept appreciating.
Right.
It kept appreciating. So the house is going up in value, 1.2, 1.3, 1.4. The loan amount that he's not making payments on, 280, 290, 300, 350, 400. So the bank had a very secure position in this house while this guy was doing a bankruptcy boogie. So then it got to a period of time. This is the best part of the story. So then it got to a period of time where before the ad would even come out in the newspaper and I would get wind of the houses being re-foreclosed again, he would literally send me an email and the email would say, meat is back on the grill. Meat is back
about
on
himself
the
he's talking about.
For that, we've always called it meats on the grill.
Meat's on the grill.
I didn't realize that's
The
right.
house
I've
being
heard
the
you
meat.
say that, but I didn't know.
The house being the meat.
Well, it's so now what's funny about this, and you guys have had experience with this, that is the normal process. And some banks have gotten this, certainly in 07, 08, there was a ton of this, and it was relatively new, and people were coming up. There were advocacy groups, and people were in weird situations. But banks have sort of understand that this happens now. They price it in a little bit, and they're a little more attentive in refiling the foreclosures. But that doesn't mean there can't be a lot of delay. And you guys have run into when you've given a private loan and somebody is essentially most of the time, if somebody's done a private loan,
They'll put their
they
LLC
don't have
into
personal.
bankruptcy.
They,
That's another subject.
it's a whole other thing about Chapter 11 is business bankruptcies or really high net worth individuals. That can have its own complications and whether you can dismiss it or not dismiss it. But the same sorts of things can happen, that there's multiple filings and delays. Now you would think, well, this is crazy. How could you avoid this? There are provisions within that 362A which allow more aggressive actions by creditors when somebody's acting in bad faith, right? That's why I started with, what is bankruptcy law for? It is properly intended to let somebody get some breathing room and refinance or deal with whatever, maybe sell the property, whatever it is, so they have a breathing room. It is not designed to frustrate your creditors. I believe the phrase is in the statute is to hinder, delay, or defraud a creditor. Okay, so delay, this sort of, in these situations.
The definition of delay.
It's delay for delay's sake.
7-year delay.
It's not that anything was necessarily going to change. And so there is a provision where a creditor can file a motion to have the stay lifted, and even to get an order saying, if there is a stay that comes down about this property, it doesn't come into effect. You can actually file that in the land records, because one problem is people can file a BK on the day of the thing and send it in, and the lawyer, Sam White or whoever's doing the foreclosure, may not know what number bankruptcy it is. At a certain number, the stay does not come into effect. But if they see a bankruptcy filing that morning, they don't know. They're just going to cancel it because they don't want to get sued for having improperly gone forward. So there's all sorts of games that can be played. And so what we have done, what I have done, we don't play by that game. That's my sort of, Citibank and others with big personal loans they're going to have to deal with that.
They're going to play the game.
Well, and sometimes what they do is as you alluded to, they will sell the non-performing loan.
That's what they'll do. They'll sell the note.
And that results in another delay benefiting the deadbeating.
Right, but they'll sell the note. That's right. And you'll see the note get assigned.
Right.
Now, one of the reasons why this is really prevalent for us is because we're in the process real time of dealing with this. So
we could use the example of the auto guys.
Well, the auto guys is one
not
thing.
a current thing.
Right, that's different. But then one of our students, we are literally, kind of me too, but so I'm helping a student guide through this whole problem in that he called me yesterday, and it doesn't matter the date. I know we're kind of taping this, but so he called me yesterday and say, I've got this property that I'm going to buy. I've got it. I want to put it under contract, but the foreclosure auction is tomorrow, which is today. Mm-hmm. Right. So I told him, I said, look, go ahead and get that property under contract. I said, you're not going to be able to probably cancel the foreclosure auction because of the contract. I said, what you're going to have to tell your folks to do, and it was owned by two individuals. And oh, by the way, they filed multiple bankruptcies, so they know what they're doing because they're a bankruptcy boogie offender. I said, just have them, get it under contract, have them file a Chapter 13 last night, get the foreclosure auction canceled, and then go buy the house.
Right.
And so we're actually going through this process with a student right now and helping them buy a pre-foreclosure that has a lot of equity in it by having them do this little bankruptcy boogie trick.
Right.
And so we're dealing with this real time.
Well, and this, again, is an example of what it's supposed to be for. In this case, a lot of the pre-foreclosures you buy, the person doesn't have money. They've got a problem. Right. However, they might have equity in the property.
In this case, they have a lot of equity.
Right. And however, they don't have money to fix it up to sell it retail. However, they don't have time. I'm out of time. And so that's what bankruptcy is for. And a proper use is you stop everything so that they can get the equity out of the property. Yeah. And
whether they go all the way through the court or they just do it overnight, it doesn't really matter.
Do it fairly short term. But again, it really depends on the scenario. So what I was starting to mention with the 362 is if you're on the creditor side, right, there's the debtor and the creditor side, you're talking about where essentially the home buyer flipper is on the debtor side, right? They're trying to work together to get the property and pay off the loan
it will
and
be
the
paid
debt.
off.
If it's underwater, there's nothing's
It's
going to
not
be
underwater.
helpful.
There's a lot of equity in it.
A lot of equity. So they're aligned on doing that. Well, what if you're the creditor? What if you're somebody who's issued the loan?
I mean, it actually benefits the creditor. They're going to get a full payoff shortly.
In that case, yes, it absolutely does. But
long
that's
as they're
the
not
thing.
upside down, right?
This is the problem, because with the bankruptcy, it can be used very, very appropriately and very badly. I mean, it's kind of like a gun or whatever. There's tools, or the internet. I mean, the internet is great for so many reasons, but if you learn how to make a bomb and commit a terrorist act, that's bad. So it's sort of, I mean, that's maybe not a great analogy, but it can be used well and it can be used poorly. So if you're on the creditor side and you see somebody that you can sort of demonstrate this, so you guys had somebody who, I think they added somebody to title, and they started trying to do the BK thing, and I filed a motion to the court saying, wait a second, court, here's what's going on. We need to stop this now. We're not going to let this drag on for 7 years. You need to know this is all being done in bad faith under the way the bankruptcy works. I mean, from their perspective, they're trying to deal with their asset problems and whatever. And so you can get an order from the court that says, oh no, this stay doesn't go into, because this is bad faith under the bankruptcy rule. Right. So what the creditor should have done in that case, if they were paying attention, even if it's big guys or it's somewhere, is they should have gone to court and said, after, I don't know, 3 years.
Yeah, but that's the problem, though, is like you described earlier, is the bigger players with the bigger law firms have so many cases like this and so much that they don't focus on these onesies and twosies, so they're not able to be aggressive. And so this kind of brings me to another bad case scenario. And I don't know if we're allowed to say their name, but it was Auto Finance.
Yeah. No,
and you were part of that case. As a matter of fact,
so these were good business guys.
Yes.
They had a wonderful business, and they entered a transaction which we discouraged them to enter. And then that transaction resulted in the owner financing calling the note.
Well, what business were they in?
They were in selling vehicles, and financing vehicles.
Used car dealership, and they were financing them.
But what they were doing was they were collecting these high value assets, that you can sell them on, these pieces of land with little buildings. So they wanted one, and it was an owner finance deal and whatnot, and they took it, and it was just not a good deal from the start, because the guy doing it was not honest, not our, what was eventually our client, but the guy selling him the place was not honest.
Well, and the owner wasn't honest.
The owner wasn't honest, and he was going to use the like a 1 day late to call his whole loan, and then immediately foreclose and grab the property back, and having taken a deposit. It was just all a terrible setup for these guys.
Right.
And so they went to an attorney, guy up in Maryland, who gave them some particularly bad advice and said, well, what you should do is file a BK as your business.
Chapter 11.
A Chapter 11. Yeah. No problem, man. Well, I'll get that filed for you, and this will stop the bankruptcy, and then you can sort out the financing. But what happened was it was filed correctly and couldn't be withdrawn. And I'm sure there's some other words that describe what happened. But that it couldn't be withdrawn. It went to a U.S. trustee that was a privately appointed person, and that person looked at their business, saw all of these assets, and decided that they would start taking action to liquidate them.
Right, and so there
was some more subtlety to it, but that's basically it. And and she took it upon herself to liquidate millions of dollars of assets and collect hundreds of thousands of dollars in fees for doing so.
Right,
when really these guys were just looking for the temporary protection, but they lost control of it.
Right. Well,
because they didn't have control of it once the trustee was involved.
Well, not only that, but the thing that they also did, and it's something you probably would advise against, is that they filed a Chapter 11, but all of their business properties were in the same name of the business.
Right. Well,
so they had all these assets within, instead of doing an LLC per property,
and it wasn't clean. They had other relatives.
Their mom
involved.
was part of it,
and that's when they were like, "Oh, we got to clean this whole thing up."
The mom, remember the mom? They filed the bankruptcy in the mom's name, and
so this is again for people who are thinking about bankruptcy. In a Chapter 13, even individually, there is a trustee who's appointed to make sure shenanigans are not going on, and that
it's an individual
to help you, again, in a good sense, help you collect. This is what I actually have. This is what I owe. All the creditors get notice. Here's how we work it out. Maybe we liquidate. Maybe we go to a 7. So the trustees are there to be sort of an objective helper for that process. So in a Chapter 11, it's because it's a business bankruptcy. It tends to be a little bit more complicated. But actually, in a business bankruptcy, normally you're the debtor in possession. So you who have filed the bankruptcy, you have a lawyer, but you're in charge of handling your assets and whatever. But if the court or somebody else doesn't like what's going on, they can appoint a Chapter 11 trustee who can become a 7 trustee to look at things. And so what happened in this scenario, and I think a little unjustly, but what can happen is if the court or the trustee or somebody feels like something is not going on right here, as simple as you just haven't filed taxes for a while, which is not uncommon,
No,
right?
this small business guys hadn't done
You
so.
and what do? You file the taxes, you get a penalty. There's ways to deal with
Sure,
this,
of course.
and typically, so at a Chapter 13, a lot of times people have filed bankruptcy. They have not filed their
Oh, of
taxes
course not.
recently.
Yeah,
It's very common, and so the first thing the court will say is, "Well, you got to get these taxes on file as part of the bankruptcy process." So it's not without risk, these bankruptcy proceedings. And in the business context, if the Chapter 11 trustee comes in and takes over, they have to get paid. Their money comes out of your assets. And so
They're selling them.
This sort of small circumstance blew up for these guys who I think were pretty good guys because you're in this mess. So the BK Boogie may sound good for some people, but it can
doesn't work for everybody.
Some bad places. Yeah.
It definitely doesn't work for everybody. But I think for us, though, in conclusion, though, if you're getting foreclosed on and you're having some real financial strife, filing a bankruptcy is a good way to at least delay.
Focus your mind on what needs to be done.
It could be a good strategy, but even the bankruptcy boogie, it could be used in certain ways to just put this thing off for years.
Right.
So you could use the bankruptcy code to your advantage if that's what you want to do. So it's a good strategy, I guess, in some cases.
And as usual, what you want to do with that, if you're really in the problem and you really want to file a bankruptcy and you really want to go through with it, there's a process in as I understand all the jurisdictions, but certainly here, where you can get a bankruptcy lawyer who specializes in Chapter 13, and they oftentimes will agree to take a case at a flat fee.
Right.
And so they'll handle the whole case for a relatively reasonable, because the paperwork's sort of repetitive if you know what you're doing. And they'll give you advice. I mean, if they should say to you, "Oh, no, don't do this. It's going to cause you this problem." Or, "Okay, but wait, you're just doing this temporary. Well, maybe you don't need me because you're going to incur all this money, a case that's going to get dismissed in 3 weeks." So definitely, seek out legal advice when you're in the middle of that kind of situation. It's worth it. Relatively inexpensive because these lawyers are used to working with people who are in a tough circumstance.
Yeah.
Get some basic from a real lawyer, not some of these fake, will fix all your problem people that are out there. If you're approached by somebody to buy your property, it is a legitimate thing that's done, and there are people that do it legitimately and people who are illegitimate. So you investigate the people, have they done it, talk to counsel. Can be a great resolution to sell your property and avoid that stuff.
Yeah.
But as we talked about, maybe it was the last, there are people out there who do not do this correctly. So your mileage may vary. Read online, look for a local attorney. It's not that hard to get if you're in that position and looking with a distressed property. So,
okay. That's it. Thank you.
Thanks.
Good wrap.
Thank you.